What's up, y'all? So back again with another video. This one is for my content creator. Obviously, content creation takes up a big piece of our time as entrepreneurs, solopreneurs, freelance creatives, etc. However, we don't often take as much time to think about the risks that are associated with some of the activities that go into creating content. And so as we jump into the new year, just want to give you a few tips, few pointers, and a few things to keep in mind as you're creating your content to help you avoid some of that legal risk and hopefully make sure you don't run into any legal issues. Let's check it out. So let's start by talking about the hottest topic probably of 2023, AI. And if you found a way to incorporate artificial intelligence into your workflow for content creation, one of the things that you should definitely be thinking about is the extent to which you can own or claim copyright over the final product. The US Copyright Office has sort of taken the stance or position that your ability to claim ownership over content that is created, content or creative work that's created using AI, depends on the extent to which the AI is the author of that creative work versus the human being the author of that creative work. So it's still an unsettled area of the law, but the main takeaway that I want you to have as it relates to the use of AI, generally speaking, the more creative input that you have in creating the final work, the more likely it is that even if you used AI to help you create it, you'll be able to assert copyright ownership and protection over that work that was created using AI. So that's tip number one. Tip number two is be really careful when using content that's created by others. Whether it's using a song, an image, video. A great example of this is celebrities who have been sued for posting paparazzi photos of themselves on Instagram, right? So Miley Cyrus, this happened to her. She gets sued because she posts a picture that was taken of her as a picture of her, but it was taken by someone who claims copyright ownership over it, and she gets sued for it. There are really kind of two main situations in which you're going to be able to legally use someone else's content that is copyrighted. One is going to be if you have a license to use that content, and that license might come in the form of, hey, we have a contract and agreement one-on-one that I can use your content for this purpose. Or it might be a license that is obtained through a content aggregator like a Canva or Adobe or Pixabay, where having a membership or paying a subscription fee is going to give you access to a bunch of different content that you can then use to create some of your own stuff. The second situation is going to be a lot more tenuous, right? So it's going to be a little cloudier, but it's going to be if you are using that content in a way that falls under a fair use exception to copyright. The fair use exception to copyright allows for people to use copyrighted material, copyrighted work for certain purposes without infringing upon the copyright owner's rights. So if your use of that copyrighted material falls under a fair use exception, you're also going to be able to use it. The thing to keep in mind is that you can't prove that your use of some copyrighted material is fair use except by going into court. All right, so if you use someone's content, something that somebody else created, and you want to claim a fair use exception, you better be ready to go to court to defend that, because that might be what you have to do in order to prove that you had the right to use that content in the way that you did. Tip number three, be really careful, and this is a simple one. Be really careful about how you use the name, image, or likeness, particularly of celebrities. People have what are known as publicity rights, which basically gives individuals the right to control how their name, image, or likeness is used for commercial purposes. And probably the key factor there in kind of making sure that you don't run afoul of any sort of legal issues there is going to be making sure that you're not using someone else's name, image, or likeness to advertise your products or advertise your services without their permission at the very least. Tip number 4, be really careful about the claims that you make about your products and services in your content. And this is an important tip for 2 reasons. Number 1, certain industries have restrictions on the claims that you can make about your products or services, right? So for example, as a lawyer, there are ethical rules that prevent me from saying, guaranteeing certain results, right? As if I was selling dietary supplements, there are regulations, FDA regulations, that restrict the claims that I'm able to make about my product, right? And so it's very important to make sure that within your industry, you understand what are those limitations on the claims that you can make about your products or services. But number 2, and the one that people really don't think about when it comes to making claims about your products or services, is that by making a certain claim about what your product or service can do, you may be creating an implied warranty. And so an implied warranty is basically a promise or a guarantee about the capabilities of a product or service that can be inferred or assumed based on the context in which a statement was made. If you're going to make claims about your product or service, make sure that you have objective data to back those claims up. And also make sure that you're careful to disclaim any warranties within your service agreements or your terms and conditions. Disclaim any warranties that you don't want to have to be responsible for. All right, number 5, if you're going to be creating content in collaboration with someone else, make sure you clarify in writing who owns the content. So the general rule is that whoever creates a piece of copyrightable content is the owner of that content. Well, when 2 people or more than one person is responsible for creating that content, they all own it jointly, and they all have the same rights to use, reproduce, create different adaptations of that copyrightable work. So what that means for you is that if you create a piece of content in collaboration with someone else, you won't be able to restrict or limit how they use that content without getting something in writing that states how they're going to be limited in terms of their use of that content. So it's important to make sure that you clarify in writing who owns the content and also what restrictions exist on how the content can be used. Number 6, make sure that if you're collaborating with someone else, that you clarify how they're allowed to use your brand. When you're collaborating with someone to create content, oftentimes you're going to give them permission to use your logo or use your brand name. If you do not limit the way that they're allowed to use your brand, a couple things can happen. Number 1, and probably most obvious, is that they could use your brand in a way that's going to damage your brand's reputation, right? And so they might stick your brand next to a piece of content which you wouldn't normally endorse. And if you don't set those boundaries or limitations early on, you could end up with your brand being tarnished based on someone else's usage of it. But perhaps an even bigger issue is naked licensing, particularly if you have a registered trademark. So naked licensing, it happens whenever you give someone a license or you give someone permission to use your trademark without any sort of limitations on that. And what can happen when you engage in naked licensing is it can lead to the cancellation or abandonment of your registered trademark. Or it's a good idea to place some limitations and be clear on what those limitations are and to monitor how your brand asset is being used by whoever it is that you're collaborating with. And last but not least, number 7, for folks who are getting paid to post content, it is important that you disclose the fact that your post is sponsored. And this may seem like it's only a social media platform requirement, but it's actually a requirement that comes from the Federal Trade Commission, right? So the Federal Trade Commission is in charge of monitoring business, making sure that they're engaging in fair practices, particularly as it pertains to advertising. And the FTC makes it clear in their guidelines that those who endorse a product through social media should make it clear that they have a material connection to the brand that they're endorsing. Now, material connection includes being paid to endorse a brand, but it also includes where there's a close relationship between the person who's endorsing the brand and the brand owners or folks who work with the brand, or any other really close relationship that might lead that person to be biased. So, as always, these tips are meant to help you out, hopefully answer some questions, and just provide information that's going to make things a little bit clearer for you as you're creating content and trying to stay far away from any sort of legal issues. But if you have any questions, anything about this that doesn't make sense, feel free to drop those questions in the comments. I'm happy to answer whatever I can. As always, this is information and not advice. But happy to see what questions you have, try to answer them, and who knows, you might drop a question in the comment that leads me to create my next video. So if you like this, as always, hit the like button. Please feel free to subscribe, and until next time, see you later.